All right, hello everyone, and welcome to Fair Use Week 2021. Whoop, whoop, whoop. Who's excited for fair use? Let's see it, give it up. All right. My name is Brent Roberts. I am Dean of Greenwood Library, and we're very excited today to be together for Fair Use in Higher Education, a conversation with Harvard copyright aficionado Kyle Courtney. Kyle Courtney, we're all so excited to be a part of this. Kyle Courtney is literally the highest form of human being. He is a lawyer. He is not only a lawyer, but also a librarian. And not only is he a lawyer and a librarian, he's a lawyer and a librarian who loves Longwood University so much. He's got his Longwood bow tie on today, my friends. Woo! Go Lancers. So welcome to Mr. Courtney and welcome to all of you. It's wonderful to have everybody here to talk about this very important issue in higher education. I am going to turn the time over to our marketing and outreach librarian, Vicki Palmer, who will introduce Mr. Courtney. And I'm going to go ahead and say at this point, if you have, so Kyle's going to give a presentation, and you can, if you have questions along the way, by all means, put your questions into the chat, and we will then address them once the presentation is completed. And I think that's all I want to say. Vicki, it's all yours.
All right, well, hello, everyone. I'm here to introduce our speaker today, Kyle Courtney. Kyle Courtney is a lawyer, librarian, and the copyright advisor for Harvard University, working out of the Harvard Library Office of Scholarly Communication. He works closely with the Harvard community to establish a culture of shared understanding of copyright issues among Harvard staff, faculty, and students. His Copyright First Responders initiative is in its 7th year and has spread beyond Harvard to reach other higher educational institutions, libraries, and archives across the country. In 2014, he founded Fair Use Week, now an international celebration sponsored annually by over 100 plus universities, libraries, and other institutions. Kyle currently teaches 2 sections of research at Harvard Law School, training first-year law students as part of the legal research and writing program. He holds a JD with distinction in intellectual property and an MS LIS. He is a published author and nationally recognized speaker on the topic of law, technology, and copyright. Please join me in welcoming Kyle Courtney.
Great, thank you very much, everyone. Obviously, visiting you, I think it was 2 years ago, was fantastic. I really enjoyed it so much, and not just because I got a bow tie out of it, but because I really appreciated what Longwood was doing for the students, and especially all the practices that were emerging from the library. So it's very exciting to be back. I realize I'm not back. I hope to join you all again for dinner or lunch or many of the things that we did in person in the future. But today we're going to cover a topic for Fair Use Week, which is obviously near and dear to my heart, my scholarship, and a lot of my work. And I brought a slideshow with me, so I'm going to do that. And the slideshow really, it's more for me than you to stay on target. There's a lot to cover here. And in fact, I'm going to start by busting some initial myths about copyright in general, and then get to the fair use. But obviously, we've been facing kind of unprecedented situations in the ability to provide access to our materials to our users, be they, fellow staffers, faculty, students, or folks affiliated with our institution in some way, and folks not affiliated, right? Getting the stuff has never been harder. And fair use certainly provides some answers to this, but I think more importantly, careful fair use analysis and actually knowing what fair use is helps get to yes more often than you think it could, or informs the risk profile that you're willing to take to digitize and make materials available, and kind of understanding those risks. So that's how I'm going to frame this today. And again, questions are welcome in the chat. I will get to as many as possible. And we're going to stop the recording at my request when we start to discuss questions, only because that way we can have an honest and off the record dialogue about some of these actions. So I think that helps with the spirit of the event here today. So let me start by starting this off. Oh, and have you look at all my email first. That would be great. Well, Zoom privacy is quite a thing. All right, there we go. Let me adjust this. And you may see a Kyle 2 in the mix here. That is my clone off to the left here, which is following along so I can see what you see. So again, thank you so much for having me here today. I cannot frame fair use as a history major without framing it in the idea that it's part of a historical narrative that's very important, which is rights that exist outside of copyright might be fun to look at and might be well understood if we look at how we used to have no rights as authors and creators. And again, this goes back to merry old England. The concept of copyright was invented in many ways in 1709, where they said, okay, you know what? We're going to pass a law that says people that create things, books, works, art, etc., will have rights in them, and that they will have the sole economic rights in them. And they will therefore be able to sell copies of their book, sell copies of their play, their mathematical theorem, and collect revenue from that. And that's kind of where that was generated from, because before that, that did not exist, right? If I wanted to publish my book, I had to give everything over to the printer, who was the publisher, and they owned the copyright, and I had no rights. So they amended that with the Statute of Anne, which is on the left. This made its way, word for word, mind you, into our law. Our first Copyright Act was passed in 1790, but actually it's in the Constitution. And this is one of those kind of unique things. Our copyright law is in our United States Constitution. That's kind of it. They invented the post office, and right next they invented copyright. That's how important it was. So that idea that it's in the Constitution says, and I have the language here, to promote the progress of science and the useful arts by securing for limited times to authors and inventors their exclusive right to their respective writings and discoveries. That's the constitutional clause. That's called the Copyright Clause, Article 1, Section 8. And with those powers, the Congress passed the first Copyright Act. Now, here's something very interesting, which I've done. I have a chapter coming out on this this summer. The first Copyright Act in the United States was not an act for authors to collect revenue. It was titled an Act for the Encouragement of Learning. I've never seen something so tied to the higher education mission that's inside such an early act. This is basically saying, you know what, we're giving these rights here so that things could be distributed and education could reign supreme. And so that idea that an act for the encouragement of learning, you might be like, oh, where did they get that? Here's another funny story. When they passed that law in 1790, as you can see, maybe you can see at the top, that was also called an act for the encouragement of learning. And I thought I was discovering something profound here, but what I was discovering was the first case of plagiarism emerged from a copyright law passed in the United States in 1790. Isn't that funny? They copied it almost word from word from the Statute of Anne. It did not cite their source. So, you know, in retrospect, we can punish them for that. Always cite your sources. So we frame copyright here in the United States as an act for the encouragement of learning. The distribution of these things is supposed to contribute to the greater learning, because that's how we promote the progress of science and the useful arts. It is my theorem that also fair use as part of the statutory code of the United States Copyright Act also promotes the progress of science and the useful arts. So we'll talk about how fair use satisfies that constitutional narrative as well. But as I always do, I go, what is copyright really? Is it a bundle of rights, a limited economic monopoly, or that constitutional narrative? And this is not a quiz, so I'm going to tell you the answer is all three, right? In order for the copyright system to work, it has to be all three. It has to be those bundle of rights that every author is given, the right to make copies. Continue. We're going to go over the bundle. Then you have the limited economic monopoly. And then after that monopoly expires, it drops into the public domain. Now, the key to all this, however, is, well, are you telling me we have to wait for this limited economic monopoly to expire in order to be able to use these materials? And Fair Use Week answers no. Clearly, that's not how the system was designed or set up. I can imagine locking up your library. Sorry, we can't get to the books till life of the author plus 70 years. That would be ridiculous, right? Higher education has to exist in the fold that is that economic monopoly. We have to coexist with the rights holder. So in order to know copyright, you only need to know these 6 things, and then we're done. We can wrap this lecture up. But it's original, creative, and fixed. We won't get into detail, but there's no registration required. Copyright's granted automatically. You get the bundle of rights as soon as something's creative and fixed. It's a wide range of works. I'm going to mention that briefly. Subject to a long term of protection. That's the for limited times has now become life the alpha plus 70. And then there are notorious and important exceptions and limitations, of which the greatest, well, arguably the greatest, is fair use. Now, fair use can apply to anything that is copyrighted. And again, as I said, anything that's copyrighted is what people create, right? Doodles, lab notebooks, dissertations, your research articles, graphs, charts, photos you take on your phone, computer code you write, maps you make, video games you take, let's say videos you take, and algorithms and coding. Now, the copyrightability, how copyrightable something is a relatively low bar, but it has to be creative. If it's not, then probably you can use it without fear of making a fair use analysis. But one of my favorite quotes about copyrightability is the range at which it can do, and this is taken from an important case with Meshworks, which is basically making 3D models of cars. But in 14 hours, Mozart could write a piano concerto, J.S. Bach a cantata, or Dickens a week's installment of Bleak House. The Laffer curve, an economic graph, prominent political debates, appeared on the back of a napkin at dinner, the work of 1 minute. All of these are copyrightable, as long as they're creative. So it's not about effort and time, which is good, because when we're framing our fair use discussions, sometimes people say, well, they worked hard on that, and therefore they should have higher level of protection. No, that is not true. Copyright just says, hey, this is all creative, then it could be copyrightable. Now, the other aspect of that is how long do copyrights last? And as I mentioned, the long term of protection is something that gets in the way of public domain, but does not get in the way of fair use. And this is, by the way, this is the reading room. My office, which I have not seen in nearly a year, is off to the right over there. You know, a long time is the answer, right? Your copyright in the US lasts your life plus 70 years, or if you're a corporation, right? Disney's not making stuff himself anymore. The corporation is. It's a flat 95 years. But after that, it's supposed to expire and drop into the public domain. And certainly many of our libraries, archives, and universities are filled with public domain materials. We don't necessarily have to worry about making a fair use analysis with them. And I'd like to remind everyone, because it was not too long ago, it was Public Domain Day. I call this Public Domain Freedom. Each year from starting in 2 years ago, every year we're going to have a new amount of materials that drop into the public domain, things that we don't have to worry about being subject to a fair use analysis. So for Public Domain Day this year, we used a recipe for The Great Gatsby, and I mixed it live in January on Zoom. So, you know, we have fun, but all of these materials are now capable of being used without seeking permission. And again, we'll have that every year. So that rule of thumb, for those of you that know, published works, government works, not states, a whole thing on states. They have their own copyright, assert their own copyright. I'd like to mention Virginia is leading in this area, and that they have a Creative Commons license attached to some of their government works. So you guys are light green in my scale of red to green. And then things that are uncopyrightable, and I bring this up example because we get asked this a lot, and you might too. You know, can I make a fair use of a calendar? Height and weight charts, rulers, calendars that are basic data are not protectable. Data generally is not protectable. However, if you add expressive elements to it, it could be protectable. So on the left is a calendar February. On the right is a kitten calendar. How is it got protection? Because they've added something to that data, right? They put in a picture of a cat. Therefore, that's the creative element. So they try to say, oh, well, this calendar has creativity enough to satisfy that. And that's why they could sell cat calendars and they can claim that they're copyrighted. But a plain old calendar, not enough. All right, so let's get back to that bundle of rights, the ones that fair use is an exception to, just so you understand what I'm talking about when I mention the bundles. This is the exclusive rights. These are on section 106. This is what you get. If you write a book, this is yours to reproduce. You can make copies of it. You can prepare derivative works, turn that book into a movie. You can distribute that. You can perform that work publicly, or if it's art, you can display the work publicly. Those are all the bundle of rights. Now, in the library, archives, and higher ed context, often we are not the owners of those materials, right? we didn't write all the books in our library. Certainly not. We didn't make all the movies. We didn't write all the poetry. We didn't, video all the films. So often we're in the university context dealing with materials that we kind of have to make fair uses of, because there might not be a way for us to use those otherwise, because we're not the author or owner. We don't have these rights. Also in the university and higher ed context, there's that idea that some of these rights may have been written by us, our faculty, our peer, our staff, but they have been signed away via contract to someone else. And just a reminder, and I will revisit this reminder again, licensing does impact our ability to make copyright determinations, right? So if I sign an agreement that transfers the exclusive bundle of rights or the entire copyright to someone else, then therefore I am no longer the owner under the law. And this is kind of odd, because I've had this happen to me. I'll be like, oh, we can probably put that article up. I wrote it. Oh, wait, no, I wrote it, then signed a contract and gave it to publisher X, and they actually own it. And they have a permissions department, right? So there's that concept that in higher ed, we're certainly fueling the publishing community. And this is why fair use is a good backstop for this, because, again, we don't own most of what is physically housed in our libraries. So let's get to the good part, fair use. So we have all that. We have the Copyright Act. And here's the Copyright Act is outlined. This is a structured picture that I've used for a year or so, where I say, here's visually what the Copyright Act looks like. In the beginning is the definition of rights, the most important ones being Section 106. And then you have fair use, smack in the middle between the other limitations and exceptions that are fairly specific and the rights section. And as you note, most of the Copyright Act here is actually limitations and exceptions. It's not the rights. And that's something that I hear a lot. We're like, well, fair use isn't really part of copyright. Oh, it certainly is. It is more than part of copyright. It is important that it was structured in such a way that it's balancing those rights out. Now, for those of you that are in the library space, Section 108 right there, really super important for libraries. We get another crack at it. Section 109, I can loan books that I've purchased, also very important. But today we're focusing on fair use. But just to say, fair use says, along with all the other limitations and exceptions, this helps define the ambit of the copyright holder's rights. The reason we can copy, distribute, share, fax, make transformative fair works from, sample, quote in papers. All of that is because Section 106 says, hey, you're subject to all these other limitations here. Yes, you get the bundle, but what you have is a statutory exemption or exception. And this is important because, again, most of the copyright is made up of this, and fair use is the most important one of these. Says, hey, someone else can use part of your bundle, right? Any of these exclusive rights without obtaining permission and without payment of any licensing fee. Now, there are some parts that say you must pay a licensing fee. For example, if I wanted to cover a song, there's an automatic fee I pay, and now I can cover that song and release it on the radio. But with fair use, it's without permission and without payment. And again, this is kind of the struggle, right? Because in this world, we're not used to that. We're saying, yeah, we get permission and we pay licensing fees, and certainly that's important. But the life and breadth of education is based on the fact that we need to be able to use stuff without permission, right? And there's underlying themes of First Amendment that come through the fair use analysis, and that we have to be able to publish these materials and quote and cite, et cetera, in order to drive analysis and newsworthiness and journalism and commentary and teaching. So it's very important. So this is the narrative we'll be exploring today, which is fair use is a right, right? Higher ed, we must maintain that right. How? By doing stuff like this, educating, myth busting, using it, exercising, writing about it, build communities surrounding it. That's the best way to ensure this. My colleague, Brandon Butler at UVA, I think he has said, or I might be quoting him, quoting someone else, fair use is a muscle and you got to take it to the gym. Having not been to the gym for a while myself, I would just say, let's just educate and myth bust about it. But that idea is that it could be our right to lose if we're not careful in noting how important it is to the higher ed community that we have these materials available and make this available for faculty, students, staff, and ourselves. So let's look at the language of the act, because this is kind of the detail that I think is always necessary. The Fair Use Act starts with a preamble It says, notwithstanding the provisions of section 106. So that's the bundle of rights. Notwithstanding the bundle of rights, it's a fair use for criticism, commentary, news reporting, teaching, scholarship, or research. Those are not infringement of copyright. Now, right after this, they go to the famous 4-factor test. But I want to focus in on this for a moment and show you they have created broad categories, which, I don't know, higher ed lives and breathes in here, right? Criticism, commentary, teaching, scholarship, research, and arguably if you have a student paper, news reporting. So that idea is that this is a natural place for us to look at and say, this allows me to do what I need to do to educate my students. This allows me to do what I need to do in order to get them to do their own learning and expanded analysis of materials that may be under copyright, but that's okay. That's what it's intended. So how did this come to be? Looking at the past can inform our narrative of the future, but when we say fair use is a right, we want to say, well, it's not a judicial trend. And I've seen that a lot the last couple of years, like, oh, you got to go to court to decide what a fair use is. Not quite. We have 40 years or 40 plus years of established jurisprudence, meaning once the fair use statute was passed in the Copyright Act of 1976, we've had many, many cases on fair use, which help define what we think of when we are like, can we make a fair use? We look to the case law. But technically, it's actually been around since 1841. So we have 40 years plus another 100 or so to deal with that. And we use this in a different way. We look at the cases, we look at the statute, and we decide what risk mitigating decisions are we going to make? Can we make a fair use of this? And this is the question. Is it a fair use? Now, thankfully, all of this case law, all of this common law gives us certainty, uniformity, and predictability. It is not unpredictable. It is totally predictable. And we're going to talk about some of those predictable markers today. But for fun, and I released this in previous year, I'd like to point out that fair use was born from higher education conflict, right? The first fair use case in 1841, which took place here in Massachusetts, was Folsom v. March. It was about a university librarian, a history professor, and a publisher, and they were all suing each other over a multi-volume biography of George Washington. That's what founded fair use in this country in the case law. And for those of you that want to read, I made a comic book for Fair Use Week a few years ago. I have the bit.ly there. Please feel free to do it. It's bit.ly Fair Use Origins. And it's an interesting question, and it comes down to it's the same as the principled arguments we have today about fair use. How much is too much? Did you make a transformative fair use? And did you interfere with the market for this? And basically, a history professor had written a 12-volume, 7,000-page set of the autobiography of, biography of George Washington. And and it was very, very expensive and very, very big. Along comes a university librarian and says, you know what? I'm going to trim this down from 7 volumes to 2. It's going to be about 800 pages. This publisher is going to sell it and people will buy it. And people did buy it, right? They preferred that one. And so the lawsuit said, you're supplanting my market. Like, this is mine. And that's what the lawsuit was about. It was interesting. It was heard in front of a gentleman named Justice Story, who was a Supreme Court justice sitting by special designation in Massachusetts and also dean of the law school at the time period. So he had 3 jobs. So he decides, you know what? I don't think this was fair. And it used to be called a fair abridgment, which is what the fair use used to be called. And he said, if you had done something fairly, it might have been a different conclusion. But the conclusion I'm drawing here is that you did nothing productive. You took that 7-volume test and you were basically clever with the scissors, meaning you copied and pasted and cut and paste. By the way, I always remind my students, cut and paste used to be a real action. You actually would cut and then you would paste. It wasn't just Control C, Control F. And so that idea is that he said, look, you were just clever with the scissors. You took 800 pages out of his 7,000 page set and you made your book, but you didn't add any commentary. You didn't add any criticism. You didn't offer any thought. You just copied. And that's too much. And that, again, is the foundation of the 4 factors and a lot of other things. So when we say fair use in the past, it's a right. This looked more like a right. And I'd also like to point out that this means the first fair use case in this country was a losing case. But that's okay. We learn from the losing decisions as much as we learn from the newer decisions. So let's move up into the more modern times, right? When we have publishing where. So the idea that fair use is a right also comes from this particular case. Harper and Row Publishers versus Nation Enterprises. President Ford had put out his memoir. And this memoir was really important because it was the first time that he was going to tell the world on record why he pardoned Nixon. And along came a book review inside a newspaper, and they used about 300 words of this 500-page tome, and they used it in the book review, and they gave away what people thought was the best part of the book, why he pardoned Nixon. And the publisher felt scooped, and now they realized no one was going to buy the book because the best part was given away in a book review, and so they sued. And the court gave us this language here, which is what I'm going to focus on. It says, hey, news reporting is one of the places that we protect fair use, right? That idea is that this is important. And it was the Senate report that said this. They were looking back at the legislative history. And they said, you know, when they created fair use, drafters resisted pressures from special interest groups to create this presumption. And therefore, they structured this as an affirmative defense requiring a case-by-case analysis. And this is an amazing language to me because, you know, it cites to a page like, hey, on page 37, they said, this is some special defense called an affirmative defense, which the law does. Now, chances are that you've run into an affirmative defense in your lifetime is probably slim. I hope you haven't. It means you were forced by the court to present a defense argument. But affirmative defense is special in the law. It says a defendant's assertion of facts and argument, if true, will defeat the plaintiff's claim, and the burden is completely on one side, the defendant. They have to prove everything. In fact, the plaintiff can just say, he did this, I rest, right? So affirmative defense is a massive shift. So they're saying, hey, this is where this appeared on page 37 of this 1967 House report. This is where we got that idea that it's all on the defense. So let's go to legislative history. I'm not going to bore you with my fun legislative history, but I found the page and I found the paragraph. And it does not say what the Supreme Court said it says. And this is disturbing to me because in 1985, they set precedent with this case, but I don't know, it must have been a clerk that got the site wrong. I don't know. But they basically said any special statutory provision placing the burden of proving fair use or one side or the other would be unfair and undesirable. That's the opposite. And I say that neither on page 37 or any other page in any other House report. And look, you know, let the bow tie fool you. I have read every single piece of legislative history about the Fair Use Act, and not once in the history of it did they say affirmative defense, which is why I think it should be treated more like a right. Thankfully, scholars then say this is express disavowal and this is a bad site. But here in higher ed, we use it as a litmus test. We don't have to end up in court to determine what this is. Because again, let's just do a plain text argument. Let's say you don't like legislative history. Former Justice Scalia, the late Justice Scalia, famously hated legislative history. Fine, let's do a plain text. What does this language say to you? Notwithstanding the provisions of Section 106. That says, it doesn't matter if you have this right. I get to make a fair use as long as it falls within this category. So this is, again, this is the struggle here that, you know, I can't decide fair use. Yes, you can. It says you can. And you don't have to go to court either. You can use it as a litmus test. This language is begging you. Please cite to my paper. Please use film clips. Please use small portions, reasonable portions of materials. We'll get to that. So again, there's some other hints in there. I won't get into this, that it's not affirmative defense, it's a right. Section 106 conditions the rights, as I said, subject to Section 107. Plus other sections call it right. Libraries and archives, we have a very special section 108 that says we can do interlibrary loan and document delivery and all sorts of other great stuff, which I'm not covering today. But it actually says in that statute, like, oh, dear libraries, there's also the right of fair use. They call it a right in the statute. So when we get to this portion and we say, all right, that means that we don't have to wait for this expiration of rights. We don't have to wait till it jumps in the public domain. That would be too far. Many university library archive and museum actions fall within these fair uses, right? In fact, we're often the only entities that provide access to copyrighted works before the copyright expires. That's our job. We have long-term preservation action and activities. Universities store, exhibit, and share copyrighted material as part of their fundamental mission, and they can do this fairly. Now, one last thing on the fair use is right, only because it's a fun story. Fair use has been called a right by the courts recently as well. So let me lay our scene. Prince, R.I.P. He hated the internet. It's a little known fact. He didn't want any little bit of any music or material on the internet at all. And for his later album deal, in which he changed his name to a symbol in order to escape contract liability, he was like, well, Prince doesn't make that album, Symbol made that album. It was a great legal argument. Universal Music Group wanted to publish his later albums. They wanted to cut a deal with him. So they promised to create the Prince legal team for him, a special team inside the Universal Music Group that would just go around on the internet and send takedown notices if anyone used any little bit of Prince music. Well, flash to some mom who's trying to share her grandkids' video on YouTube. And her parents lived across the country, and so did her in-laws. So she would take videos, post them directly from her phone online. And one of them was her son dancing to Let's Go Crazy. It is a 30-second flip phone video, so that the camera is not very good. And the audio is very garbled. Of those 30-something seconds, about 22 or 4, you can hear a little bit of the chorus of Let's Go Crazy written by Prince. And she got a takedown notice. She was like, I'm just trying to share a clip with this kid's grandparents. So she responded back. It went back and forth. And I'm not joking. This was 11 years of litigation over this clip. And because she was like, nothing will stop me from getting my grandchild on YouTube. And it was all because of the Prince team. And they were clearly overreaching. And the court eventually held, like, hey, you know what? This is a problem because people are assuming this is some kind of affirmative defense. This is a right. Labeling as affirmative defense that excuses conduct is a misnomer. It should be viewed, since the Copyright Act of 1976, as a right granted by that act, and is logical to view it as such. And she eventually won that idea that takedown notices like this should take fair use into account. What we can learn from this certainly is that if there's no market harm here, so if you and I went out and we're like, you know what, I'm going to go pick up that new Prince album. Oh, wait, no, there's a 24-second garbled version of it on YouTube. I'm just gonna listen to that instead. People might think you're crazy, right? That is not replacing the market. There's no way. And I get why Prince wouldn't want a bad version of his work out there, but here that wasn't really harming the market. So when we ask ourselves, is it fair use in higher ed? Often we look at cases like those that are not in our field. Thankfully, there are not a ton of cases where universities and libraries are sued for copyright infringement and have to defend under fair use. There are some, but there are not a ton. So this is why we look to other cases, and this is why doing copyright inside libraries, archives, and higher ed institutions and museums, any cultural institution or educational institution, is hard because we don't have as many on-point cases. But this should give us hope, because we can use those cases to analogize our uses. And we can say, what did this court decide? Okay, how are our facts similar? And it helps us to mitigate risk. But in higher ed, the things that we're used to are generally fall within a pretty clear fair use, right? Here's a classic one. Using a quotation from an earlier work in your critical essay to illustrate the essay's argument. Imagine you had to get permission every time you quoted something in a term paper. I mean, we've been doing this since grade school, right? If I'm gonna, I use a piece of a poem, I cite to that work, I cite to that sentence, I cite to that chapter, and then I'm criticizing it, I'm talking about it in some capacity. So this is clearly a fair use. Where would term papers or midterms or any research paper be unless you could quote? And again, technically you're using it without permission, right? You're saying, I'm going to use this. That's, a fair use. How about including a photograph and a presentation for classroom discussion and commentary, right? So for classes that are in art or music or something where they have to present the thing, they say, all right, let's talk about this thing. You have to be able to see it in order to talk about it, to engage with it. And you have to be able to reproduce it. That's what fair use is supposed to allow. How about reading a poem in a campus lecture about the particular poet's use of language? You need the poem. It's necessary to see, hear, interact with the poem. And what I'm getting towards here is the notion of transformative fair use. We're not there yet, but that idea that it's necessary, it serves a different purpose, it's an educational context, and it's not hurting the market. This is where higher ed seems to fit best in that. But for the moment, let's look at the regular old 4 factors of fair use, right? The idea and concept here is that we had the preamble that says, hey, commentary, criticism, teaching, research, scholarship, not fair use. And then please use this test to make that determination, right? And this is the 4-part test. Now, I've been waxing poetic on fair use a lot recently. I kind of wish there were 5, because then there wouldn't be a tie so often. And that's just the way it goes sometimes. They made 4 factors. So when there's a tie, you got to use your best judgment. But again, how are we using these factors? We're using them to make a determination about whether or not our use will be fair or will likely be infringement, right? So let's just go through them. Factor 1, courts have come to a sort of consensus on this and said it's more likely to be fair use if it's nonprofit, educational, teaching, criticism, commentary, scholarship, research, notice reporting, all those things. And preview when it's transformative or productive. We'll get into that. Great, because that's where I think education lies best. When it's more likely to be infringement, it's a commercial ruse. It's for profit. It's for entertainment, right? It's not for teaching purposes. There's bad faith, or you take out credit to the author. That happened last year. A high school had like $1 million judgment against it because they handing out biology cheat sheets, you know, those big ones that are very handy that have everything written on them that a vendor produced, and they blanked out the copyright statement at the bottom. And the court was like, no, that's just straight up bad faith. You're denying credit to the author. No fair use. So again, character of the use important. Second factor is nature of the use. This is the most ignored factor over the last 20 years. And I understand why, but hear me out. If something's more factual and it's published and available, it's more likely to be a fair use. The more creative it is, the more protection it should have under the Copyright Act, or if it's unpublished in some way. However, we've seen that wall come down a little bit, because why shouldn't I teach with music? Like jazz is highly creative. But if I'm taking a jazz class, I would expect to hear some jazz, right? You know, I have to use a certain amount of these materials, even if it's super creative. So we can't just have boring factual works all the time. We have to have the scope and breadth of education, use lots of materials. So that's one thing. Factor 2 gets ignored a lot. Factor 3 is probably the one that gets, if not the most focus, the second most focus, because it's like, how much is too much under fair use? And there's no direct answer. It's quantitatively and qualitatively, right? It's dependent on that. With that presidential memoir of President Ford, you know, they said, hey, you use the heart of the work. The most important part is why he pardoned Nixon. You know, we have some language like that, but more likely than not, they look to, is it a small, reasonable amount? Is it reasonable used in proportion to the purpose that you're using it for? Or are you using too much, a large amount, a heart of the work, or just way too much stuff? And then lastly, Factor 4. Now, this is supposed to be a balancing act, right? You have 4 factors, you're kind of weighing your risk. Some courts have said this is the most important factor. Some courts have backed off on that. Recently, I've seen the pendulum start to swing in the other direction again. Like, maybe it's important, but if you can imagine, it's where copyright hits the creator right in the wallet, because your fair use might, you know, replace their market, might. But this is why we have to examine it. So if there's no effect on the market, there's no place for you to get permission or a license, or if there's a used copy available, or there's not many out there, it's out of print in some way, not being part of the market, it's probably favoring fair use. Everything the opposite of that, right? It replaces sale, it replaces work. And this is why I use that Prince example of, like, there's no way a 24-second garbled video would replace a sale of the song. If I want to listen to Prince, I'll go out and buy a Prince album. You know, so there's that part of it. Now, in a very interesting study that was done a few years ago, it studied all the statutory fair use opinions from 78 to 05 and found that when you come up with an analysis where the first and fourth factors match, then it's going to go in that direction virtually every time. So if you find fair use with factor 1 and you find fair use with factor 4, 72% of the time, it would be a fair use, which is for law, that is a huge, huge number. And by the way, they're doing a follow-up on this article now, so hopefully I'll have some numbers, but I suspect they're the same based on just my reading of case law consistently. So Barton Baby put this out a few years ago. And why 1 in 4? Well, because of the development of something called transformative fair use, which came about in a law review article in the 90s and then made its way into the court. So it jumped from the scholarly into the practical, which in my field is very rare. That idea, like, wait, a law review article led to some kind of reform? Yes, but this is important. It kind of takes this 4-factor test and whoops, way off. And my drawing is terrible today. Sorry, never use Zoom tools is what I just learned. There we go. So that idea, it takes these 4 factors and it collapses them into these 2 questions. And these 2 questions, I think, are critical inside the educational marketplace. Does the use transform the material by using it for a different purpose? And was the amount taken appropriate? Now, where you're saying, well, where is factor 4? Where's the market? The market is kind of built into number 1 here, because the more transformative something is, the less likely the court will care about commercialism. Very interesting. So let's talk about that. Let's talk about higher education and transformative fair use, which is the newest and freshest version of fair use. So use of a quote, image, clip, or anything is substantially more likely to be a fair use if it's transformative. But don't force it, the analysis, but we'll talk about it. So a work is transformative if the words of the Supreme Court, in this case I'm about to show you, add something new with a further purpose or different character, altering the first with new expression, meaning, or message. Well, where does that come from? It actually comes from a parody hip-hop case, which is Campbell versus Acuff Rose. And this was the case that took transformative fair use out of the law review and put it into the courts. And it's a Supreme Court case. So this is the law of the land. So when we're examining this case, we're thinking about, okay, how does my library or my educational institution or my archive or museum do transformativeness? Well, they say basically that you can take something that's original and do something to it with a new meaning or message. Here, the rap group 2 Live Crew took Roy Orbison's Pretty Woman and put it through the lens of their cultural understanding of where they grew up in North Miami. So while Roy Orbison was writing about, I don't know, a brown-eyed girl from Charlottesville, they were writing about a local streetwalker that they knew. They used as much material as possible. They borrowed the hook, they sampled it, and they rewrote all the words reflective of their experience growing up in North Miami. And this was found to be a transformative fair use. They applied a different meaning, a different message through the lens of their experiences growing up, knowing the Roy Orbison song, but applying it to their situation. And the court even says you need to give the artist room to breathe. Now, this has come full circle because just a few months ago, there was another case that was very similar to this. And I was glad to see that the origins of fair use coming from the sampling hip hop community was returning back to it. Drake, who his actual last name is Graham, he was sued over a 35 sample clip of this gentleman named Jimmy Smith, who was a jazz artist that in the late 70s, early 80s, recorded something called the Jimmy Smith Rap. And in his jazz free word spoken jazz album, he said, jazz is the supreme form of music and will always be there. Every other form of music will die off. And in this sample, Drake released his song. The song is called Pound Cake. They used that spoken diatribe as the intro to then refute Jimmy Smith's theory in his 35 seconds. And he says, no, it's not jazz music that reigns supreme, but rather all real music, regardless of genre, will last. And this is kind of interesting because the court went in and examined the lyrics. And just like they did in the 2 Live Crew case, and they said, okay, what was the intent here? Well, you have to quote portions of the Jimmy Smith rap in order to make your assertion that that is false, right? And this is basically, I'm like, they did a term paper in the form of rap. I needed to quote and use this much, 35 seconds to sample. And as a result, they did not have to pay for that sample. And again, this is a clear transformative fair use. So when we look at this test, we're looking at how does our educational use kind of mimic that. And sure, fair use of materials in education is important, right? That idea that we are making transformative fair uses. But let's start with a category of materials that gives everyone trouble. And that would be unpublished materials, right? The materials that are in our libraries, that are in our archives, that have never seen potentially the light of day in the former publication manner. And I'd like to go on record and say I did write a comic book about this, because this is all based on the Salinger versus Random House case. And again, once again, we're looking to the commercial marketplace here, and we're looking at cases that don't necessarily involve libraries, but this one ended up involving libraries. So Salinger was a very private guy. Hopefully I don't have to explain who J.D. Salinger is, but he wrote Catcher in the Rye. I've just explained it. And he was super private, and he had donated some collections of materials to a university library, but also people that had letters from him also donated them. So this university archive had a collection of letters and stuff, and a scholar came and said, I would like to access those, and I'd write, because I'm going to write a book, a biography, right? And his name was Hamilton. And he went through the ringer with Salinger. In fact, he tried to ask for permission at first, and Salinger said, well, no. And then he asked again. He said, okay, well, you can use some of this. And then he actually cut all of his quotes down to paraphrase, and he tried to use as little as possible while still being able to write a book about these events. And again, he cooperated with Salinger. Finally, Salinger said, you know what? I don't even want you to paraphrase from these materials. These are my unpublished works. And imagine that. Imagine being like, you can't even say what you read in the university archives room. You can't even be like, I never read it. So this was a bit too far. And unfortunately, the law at the time was highly protective of these unpublished works. And the default judgment was, well, they're unpublished, therefore they're not subject to fair use. And the world freaked out. This was 1991. And librarians, historians, archivists, publishers, authors, scholars, higher ed finally got on the same side over something. And they said, holy cats, we can't have this. And why can't they have this? Well, let's start with the author. The author's like, if I quote from these materials, I'll get sued. That's not good. If I quote from these unpublished materials, I'll get sued. That's bad. The publisher says, holy cats, if the author quotes from these unpublished materials, then we get sued because we produced the book. And then the university libraries and archives said, holy cats, if we give people access to these unpublished materials, we could get sued for that too. So everybody was scared. And as a result, an amendment to the fair use statute was passed that said, and this is the language that was added to the bottom of fair use in 1992, the fact that a work is unpublished shall not itself bar a finding of fair use. So this is good news for a lot of our materials that we have in our collections that are unpublished, because we can say, all right, the 4 factors apply. So that's one kind of category. Another interesting category, reserves and other limited access materials. Now, I'm sure all of you probably went through the reserves rage of the summer and fall as we were grappling with making things accessible. I'd like to just point out my favorite thing. Here's the original reserve system. It was invented in the 12th century. This is the chained library. And what's going on here, you may say? Well, if I want to use a book, I can take it off the shelf and I can put it on that bench there and I can examine it. If I try to leave the library with it, I cannot go anywhere. So I am forced to share this book with everyone else that has access. I would like to make the case that reserves today have the same functions, whether they are online or not, right? So I'm leveraging technology for e-reserve management systems, right? It could be Blackboard, it could be Canvas, it could be Moodle, it could be a lot of things that you have and that you do. You're not creating a new methodology here. And I think that's of critical importance. You're using technology to enhance access, or in many ways, increase access. Now, there's a struggle here that occurs, right? Certainly, we're used to reserves being maybe articles as they exist on Blackboard or Canvas, but could you use whole books? I say you can. And we're going to talk about that in a moment, but the battle cry from the rights holder organizations is no, 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 those are called course packs and you need to pay for those. And this is kind of a confusing narrative that I think it only exists in higher ed because we're the only people making reserves, right? So that idea is reserves are supplementary print or electronic course materials that the staff put on hold with limited circulation periods, like the chain library, to be shared by a lot of patrons, right? And the law under this is fair use or first sale. And I know I'm not going over first sale, but that's basically the right. If I buy a book once, I can loan it to thousands of people without ever paying again. That's first sale. That's why libraries exist, right? But also under fair use, if you're going online, if they're housed at the circ desk or they're housed in an electronic reserve system. Course packs are a series of specialized terms that developed in the mid-90s, where copy shops were on campuses taking 20 parts of 12 different case books and putting them all together and supplementing the market for a case book or a course book, right? So if I wanted a history textbook, somebody was like, you know what, I just use these 5 textbooks and I put it all together, and that is a course pack and I'm going to sell it to you, right? And there was a bunch of lawsuits about this. It basically says these are assembled to supplement college and university courses, but you could also assign a history book. And it came to be that is because one of the major publishers was like, how come I haven't sold an American history book at the University of Michigan in 2 years? Like, how could that be? They're not teaching history there anymore? And no, they were assembling these course packs. Those decisions rendered this permission-based licensing. And most notably, these were happening outside the auspices of the library, right? Copy shops that were on campus. And by the way, they tried to declare a fair use because they were nonprofit educational. And it was not that. These, Kinkos and everything were just renting space from the University of Michigan or Cal now. They weren't there out of the goodness of their heart. They were making a hefty profit, right? So there's a difference here in the business methodologies. Libraries have a specialized mission. So that's all going, well, it's going moderately well. And then we have the pandemic, right? So let's talk about this, adjusting how we conceive of fair use. So let's say you had a normal reserves policy, 1 to 2 chapters, 1 to 2 articles, 10 to 20%, whatever you have, if you have as a policy. Actually, I should probably ask you what you have as a policy, but not right now. So then all of a sudden, COVID strikes, right? Schools, universities, libraries, campuses close or are not at full operational capacity. And that's enough sometimes for this. What was happening in the spring, because I was teaching, my course got shoved online unceremoniously, I might add, right around late February, early March. And some students said, we can't get reserves. We can't get to our textbooks. Some of them got abandoned in our dorm room. I mean, some of these closures were get out, right? Or we're closing the library down. We haven't figured out curbside pickup yet. Or we don't want to share a reserve material because there's problems with that, right? Everyone touching the same item. A lot of people were like, oh, well, we have pandemic fair use. And my thing was like, well, no, there's not emergency fair use. There's fair use during an emergency. And there's a slight difference there. Let me explain the difference. Fair use provides an expanded, flexible analysis based on the factual situations that you bring to it, right? If you're doing your litmus test, is this a fair use? You present the facts. The facts said we're closed or not at operational capacity because of a pandemic. And so that idea of like, oh, using as much as necessary, maybe we measure from the syllabus, maybe we look at the class readings, maybe we say, oh, they have to have these materials for final exams. So pandemic emergency access can change. Now, I know a lot of the publishers came out and said, we'll give you this for free. But as you probably all well know, there's no such thing as a free lunch. And here they were saying, but give us all your data, have the students sign up, give us all your emails. We want your IP ranges. It wasn't quite like getting a book. So fair use becomes flexible. And let's talk about programs, and I've reviewed a number of them that use controlled digital lending or digital reserves, or my favorite one is called LOLA, Library Online Access, which was intended to mimic the reserves function, right? So let's say the university owns a copy of the book. Physical reserves for sale says, hey, many users can access this book, but wait your turn. And what that's doing there is creating a friction, right? There's a friction that exists in this Copyright Act that or maybe even a speed bump. I have to wait for so-and-so to be done with the reserve work in order for me to go to the physical desk, take it out, and then I get it next. I get it for 3 hours, and then after 3 hours, the next person in line has access to it, right? So you share. The digital reserves programs I've been working with around the country said, hey, technology can decrease that turnaround time. That idea is once a user is done, it transfers right to the next user if it's in a system that can do that. So this is why adopting technology may be helpful. It prevents that friction. And by the way, the friction is not protected by copyright, right? That's not the intention of it. Now, some people say, well, shouldn't you buy licenses for that? Isn't it harm the market? Well, not really. Most of the libraries I talked to said we buy 1 or 2 copies for reserve. We certainly do not buy 50 licenses. We certainly do not buy 50 copies. Reserves are intended to fill a particular need of a particular class. So I would not buy any more or any less than I would. So as long as I'm mimicking that, the idea that digital reserves doesn't negatively affect the market any differently than the legal uses already permitted by libraries when lending books physically, right? That idea, like I bought 2, these many checkouts occurred to that time period. Why can't we utilize technology to mimic that cycle? As long as you, by the way, you're doing it in a way that doesn't allow them to reproduce the work. So that idea that like, I'm not giving them a PDF and being like, good luck, kids, right? You're giving them it in a lockdown way. There's many versions of this. People are using Alma D, they're using Dropbox, they're using Google Drive, they're using all sorts of other ones. Even HathiTrust, their emergency temporary access system is a version of this. You can only look at it. You can flip pages digitally. Internet Archive uses Open Library, very similar. You can't download it. You can't do that. So in that way, it's replicating the library's super special mission that they have. And, I doubled down on this at the height of the pandemic when I helped draft a public statement. Basically, fair use in emergency remote teaching and research. Basically, legal obligations do not automatically dissolve in the face of a public health crisis. We have no precedent for that, but U.S. copyright law is well equipped to provide this flexible necessary, and that is fair use, right? And that's helpful. Otherwise, and this is kind of interesting, imagine your library is closed or limited access and pickup, and the answer becomes, well, you're going to have to buy a license for all the books you already collected, right? And that's fair use preserves the legal and significant fiscal value of collections, right? That idea that we can have and own and acquire that and give it without having to buy a license that doesn't let us do what we want to do, right? Ebooks are not sold to this. I'm going to get into this in a moment. The problem is that there were many other opinions out there on what should be done during this time where we're doing more remote access than ever. This is a letter from the Copyright Office. It's like, hey, good news. Licensing is expanding. And good news, Penguin House and J.K. Rowling have created a new license that permits people to read along with this has gone off the rails. And I did a whole thing on read aloud licenses and story time at public libraries. I just want you to say, the moment we start to charge fees or have licenses for people to read in literacy programs to children, we've gone off the rails. You do not need a license to read a book out loud to a kid. I will go on the record as saying that. So these read aloud licenses were scary to me because these books are in the classroom, and certainly it seems like it would be a fair use to read something to somebody and then discuss it and learn and have educational outline from anyway. So more people started buying streaming media. Some people started buying this. And this statement here from the Copyright Office concerned me a little bit. It's generally understood that many uses of copyrighted works by schools and university must be licensed. I don't think that's generally understood. I refute that. And in fact, footnote 61 there cites back to the course pack cases, not the reserves, right? And so I was very interested in that, though, that everything must be licensed. So I'm saying I don't agree with that. I think fair use can fill some of it. Should we use some licensing? Absolutely. That's part of our ecosphere. That idea that we will use some licensing, but we don't have to license everything. That's very important, because licenses interfere with the university mission for preservation and access. If the license says no downloading, no sharing, no ownership, no copy, that's a problem. Now, let's talk about movies and media in the classroom, another place that fair use kind of reigns supreme or is very terrifying. Depends on your view, I guess. Will Cross out of North Carolina State University is a friend and colleague. We did a great lecture for last Fair Use Week. I think it was. What happens when Netflix is dead? Now, it's a very dramatic title on purpose, but it's how restrictive licensing threatens future of our cultural heritage, meaning, God, we don't own any of this, right? So maybe many of you have experienced this when you've, I don't know, tried to transfer music on your iPod, or you tried to share an ebook with someone, or you can't buy an ebook, or the license is too restrictive. Licensing is not so much helpful to a university mission and mandate. And I would especially say to the libraries and archives inside that university. And why is this? Because they're generally restrictive, but they are a separate area of law also. As I said in the beginning, most of the scholarship that's creative, scholars may sign their rights over to someone else. Same thing happens here. Licensing is a contract, an agreement to specific terms that can change, alter your rights, including your copyright. So these are separate fields. So I would say licensing material makes the university library and archives mission impossible. It is very difficult because, we have this, streaming media problem, and ownership is questionable at best. On Monday for Fair Use Week, I did the end of library ownership lecture, which was kind of a bum out lecture. But we talked a little bit, obviously, about fair use. So I just want you to see for a moment. Here's an example of a typical e-media license. Now I'm picking on Netflix here, but it could be any one of them. It could be any of our ebook vendors. It could be any of our movie, film. It could be Spotify. Basically, this is for your personal and non-commercial use only and may not be shared with individuals beyond your household. Now, I consider all my library colleagues family, but I definitely would not refer to them as the household. That's very specific. And you have a limited, non-exclusive, non-transferable right. So you don't actually own it. And you agree not to use the service for public performances. So you can't do a lot with this thing. But most importantly, you don't own it. This causes you to be a renter. So it's a personal renter. So one of our earliest questions that came up during the pandemic, can I use Netflix in the classroom? Let's talk about it pre-pandemic. If I showed Netflix in the classroom pre-pandemic, I'd be violating this license. Not to mention post-pandemic. I mean, that idea is that this is not set up for us, and Netflix will not sell you a DVD, and they will certainly not grant you a license that's worth anything to a library for long-term preservation. They can give you temporary okays at best, but you do not own these movies. And more of these movies are not getting backed up or preserved. It's problematic for libraries, and it's problematic for our mission. In addition, just in case you're worried that this personal non-commercial use only was enough, they also say you cannot archive, download, reproduce, distribute, modify, display, perform, publish, license, create derivative works from, et cetera, et cetera, et cetera. So all of the library rights we have, and half of those are fair use rights, you can't do. It's just forbidden by the license. So hopefully I've pointed out here that e-media licenses, no matter what they are, limit you to ability to make copies, transmissions of the work, permit limited access, probably no access at all for certain universities, and don't allow the university to keep a copy of the works when the license is terminated or expired, right? Again, going back to the thing, what if Netflix is dead? Where does all that go? This is the critical underpinning of a university library's mission, is to save some stuff that's important to the community. And I'm not saying we need to, get everything on Netflix. Somebody's probably going to save Narcos or any of the other series, but there's other documentaries and all sorts of great stuff on there that is used in education more and more and more. So what do? I'm not sure, but here's my pitch. We do have fair use. We do have fair use. And people are saying, well, the license doesn't say no fair use, right? The license just says you're renting this, right? And so you really can't use this in the ways that you forecast. And I say, I feel like showing something in a classroom, regardless of the license, is a copyright fair use decision and not a licensing decision. And that's where we kind of have a middle ground with some of this. We have to be more accepting of low risk as higher educational institutions, because first of all, there's no such thing as no risk. I'll say that as a lawyer, I'll also say that as a commuter on the Boston train. There's risk in every step. But that idea is that there's no such thing as no risk. So we have to learn to embrace low risk. Certain uses, nonprofit, educational uses that could be transformative, right, might be a low risk scenario. And so, when we think about making fair uses in education, we can think about scenarios in which our low risk may be a licensing risk as opposed to a copyright risk, because they can come after you for all sorts of things. But conceptually here, I think we're in a good spot to start because, and I hit the wrong button. I'm sorry. Because you can listen to me for a moment here. Hello, discard, sorry. As you're listening to me and learning. Because the last little bit that I'll do here is an example of a transformative use in a scholarly case. Where did hold on a second, share. You'll have to forgive my Zoomology here. There we go. So let's say you're a PhD candidate using images from the internet, right? Here's an example of like a transformative fair use, or at least one. Let's say the thesis is on comparative music trios in history. Again, this is based on a real thesis that I dealt with. And it's studying the musical differences in instrumentation and sound recordings and music sheets. That's the thesis. The thesis is there's musical trios in every culture. Here's the music sheets. Look how similar they are. Let me use an algorithm to cover this. But they want to put this on the cover. Pablo Picasso's under copyright. Well, everyone's like, oh, well, it's education. It's part of a thesis. It's a nonprofit education. Not quite, right? Transformativeness is applying a new meaning, a new message, adding something there. So when I'm thinking about transformative fair uses in higher ed, I don't want to think about, window dressing. I want real solid illustrations of a content. So if I'm going to include something, if I'm going to send something somewhere, and I want to throw down on that and make it transformative, analysis, commentary about the painting itself. Visuals for visual sake, not so great. So I always like to change this analysis. What if the thesis was on comparative musical trios repping in modern art? Okay, now you're getting closer, but I still wouldn't put it on the cover. I need to see the analysis, move it inside the paper. If it's so important, put it on the page, surround it with some analysis, right? Look at the amount necessary. Do I need the whole thing? Am I just looking at Picasso's signature on paintings? Then I just need that part. This comes down to my favorite example, and then I'll end. We were teaching a class called Einstein X, which was about the theory of relativity. It's a math class, ultimately, physics and math. And they wanted to use this highly copyrighted photo of Einstein. And it was like, you must pay. Like every website, it was like, this goes to an estate, this is a thing, blah, blah, blah. And I said, do we really need to see a picture of Einstein to learn about his mathematical theory? And the answer generally is no. However, I could be convinced if we were talking about Einstein, the person, the hair, the photo, the image of him at that time period and analyzing it, if we're doing photos of Einstein, I could see that going in that direction. So again, consider that transformative fair use in higher education helps if it's subject to scholarly analysis, if it's illustrating an important or critical point, or it's repurposed in some way. Think about the 2 Live Crew song, repurposed for a significant educational reason, right? And that helps. If I need to use a copy of the Avengers in class to teach something, it has to be for a new reason. I'm not just showing it for fun, right? I'm showing film, camera, modern visual equipment, etc., or the narrative of the superhero. I could get behind that. What I can't get behind is I'm just trying to show this for illustrative purposes because it looks neat or it's fun. So if we're kind of setting out our goals for that, the more transformative it is in the work that we do for fair use, the more likely we are going to be able to embrace that low risk and say, you know what, this is a nonprofit educational transformative fair use. And I need this. It needs to happen in order for education, criticism, commentary to reign. And you're in a pretty good space for that already, working at a nonprofit educational research center, right? That helps. That helps it right away. So I'll end here. I obviously give late 20 minutes for questions,
Thank you, Kyle. And we want to thank everybody who has participated today and wish everyone a very happy Fair Use Week.